All right, and we are back. We are now going to talk about collections. This will probably be one of the meatier portions of the course. So, collection companies are one of my favorites because they're illegal, right? There's no valid contract between, let's say myself and another collection company, um, where we brought something to the table and we're going to exchange. We already agreed to exchange, services with each other for anything, right? Uh, that's why they're illegal, right? A lot of people say, "Oh, what if their assignment is legal, so they can be assigned it from Sprint?" Okay, fine. So then we just take the collection company and Sprint to court because a our personal information should not be shared to the credit reporting agencies without our permission, right? We went over that in the first part, right? Episode 4, right? 15 USC 1681B A2, without the express written permission of the consumer to whom it relates. So that is $1,000 penalty right off the bat. So we just take them to arbitration and we get it all cleared up anyway. But that's for further down the line, probably in the mentorship. But right now, this is just a basic overview of collection companies and why a lot of my clients come to me for collection removals is because they're illegal, right? So they're illegal in nature because they lack the fundamental rule in commerce. They must be a valid contract between both parties, right? You and I have to shake hands and we both have to sign something that says, hey, I'm willing to do business with you, da 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 da. If there's no contract, what is it? It's a unilateral contract. We don't do those. Those aren't allowed, right? Corporations are legal fictions, right? AKA fake entities, and therefore are unable to physically sign anything, right? That's why you have the ability to say, I want to face my accuser in court. If a lawyer just shows up to represent Capital One, that lawyer can't speak for Capital One, right? It's illegal for them to do that. If they have done it, it's because the person didn't know their rights. You speak up. You can say, Your Honor, is the lawyer testifying? And if the judge will have to ask if they're testifying. If they're not testifying, then they can't talk about it. They have no firsthand experience. They have to have firsthand experience of the account nature. So when you say that, the lawyer can't speak, Capital One can't speak, they're not there. So case gets dismissed, right? If these companies physically can't sign anything and the consumer never signed anything with the collection company, the entire process is illegal. It is illegal because the collection company created what is called a unilateral contract, right? Only one side benefits, right? The only time a collection company can say a consumer entered into a contract is if a conversation is had on the phone whereby the consumer accepts or claims the debt in question. All right. So I always tell my clients never answer the phone. I don't care who it is. I mean, if it's your mom, obviously answer it, but don't answer the phone if you don't recognize the number because it could be a collection company. And once all those calls are recorded. So let it go to voicemail and then record the time they called you. Because if it's after certain time periods, it's illegal violation, $1,000 penalty. All right. There's so many ways these debt collectors are violating your rights. That is crazy. But people don't know these things because, again, school doesn't teach us this stuff. So that's what I'm here to do, help you guys protect your consumer profiles, right? Know how to answer their calls correctly, right? Collection companies always attempt to call first, and they typically send mail using language that would indicate calling them back is easier than replying via mail, which is not the case at all, right? This is an attempt to trick the unaided consumer into agreeing to pay for the alleged debt or obligation. It's alleged because you never agreed to it, right? I can show you the federal definition of debt is a debt or an assumed debt, right? It's it's like it's not it's a debt or an alleged debt. So that's the federal definition of debt. So unless you claim it is alleged, they got to prove it. And these collection companies can't prove it because they don't have all the documents. When they assign, when Sprint assigns, let's say the ERC, a collection account, Sprint doesn't give them your social and all the other stuff, the original documentation. So what's in order to prove that you have entered in contract with that company, they need to show you the wet ink contract from the first one. They can't show you a copy. They need to show you the original, and they can't do that, right? So I don't care what these companies have said in the past. If you've been dealing with them, I don't care what's been going on. Are not, as long as you are coming from a place of education, they're going to leave you alone, right? Once a consumer calls and claims and verifies the debt on the phone, which is a recorded line, or the consumer makes a payment to the collection company directly, the consumer has now entered into a new contract with these debt collectors, scam artists, etc. They're scam artists to me. All right. In order for a valid bilateral contract to exist, the following must be presented: offer, acceptance, consideration. So when did ERC offer you anything? Never. Before they just put out your consumer report. Never. Acceptance. When did you accept? Never. Never happened. Right. So there's no contract. Contract law states in order for there to be a valid contract, these items must be present. So if they're not present, people, they don't exist. Right. So I'm telling you, like these collection companies, illegal. Wouldn't stress out about them. Right. Easy win to get off. And if they want to give you a hard ball, sign up for the mentorship. I'll show you how to sue them and get paid. Easy. Here's the dispute process for collections. Okay. Here it is. We always deal directly with the collection agency first. I don't go to disputing the 609 method. If you've ever had a course before, they teach you that. That's dead. We don't do that because it's just going to be Oscar and they're going to verify it. We don't do that. Right. So we go straight to collection company. Right. So step one, preparation before dispute, send dispute directly to collection company first. I already mentioned that. We want to verify the name and address with the BBB prior to sending the dispute. Now, why I say that is because sometimes, depending on who you get for a credit monitoring service, there's many of them out there, too many for me to list. I mean, there's Identity IQ, there's ID Club, there's Experian, there's Q in the background. There's a bunch of them. And sometimes what'll happen is you'll see a different address under the account. So when I used to use Identity IQ, they would list the original creditor, but then they would list the address of the collection company. And so the disputes weren't going anywhere they needed to because the address didn't match. So now I tell everybody, hey, just verify the name and the address with the BBB, which is the Better Business Bureau. And that'll be your first step before we send anything out, because that way you'll know, okay, if that's the address they have on the BBB, that's the address you need to send it to, because if that's not the correct address for communication, then it is illegal that they're not sharing proper information with the government. So why not use the one that they have to use, right? A lot of the time, the collection company's name is shortened on the consumer report. So, for example, if it's ARS Account Resolution Services, it'll be like ARS, right? ERC, Enhanced Recovery Company, sometimes it'll just be ERC. So I always type out the full name because that's what is put on their articles of organization, which is the original document that they had to file with the state when they became a company. So I don't use their abbreviated name, I use their real name. And that's what I suggest all my clients do as well. So step two, letter preparation. Our first letter is refusing their offer to contract and cease and desist, right? So that's the first thing that we're going to do. We're going to tell them, hey, looks like you're attempting to enter into a contract with me from this phone call or this letter. I'm refusing your offer to contract. Please cease and desist all communication as it pertains to this alleged account. We never expressly agree that it's our account, right? Don't put that in writing. But we always tell them, hey, cease and desist all communication in regards to this alleged account, right? 9 times out of 10, they're going to respond with something like we validated or verified. As you see here, we are not asking them to validate or a debt we never entered a contract to owe. So I never, I always put in my letters, this is not an attempt to verify or validate the letter. Any response that includes the words verification, or this account has been verified or validated, will constitute as harassment, because that means they're not reading the letter. So if they send back a response that says that, now I have more ammo for when I sue them later in court, because I already told them you can't, I'm not asking you to verify anything, and I have the proof. So now when I take that to the judge, who would then believe me or them? I was like, oh, Your Honor, I told them. It's over. Like, you guys have to learn the court system. I know that as people are afraid of court, it's time to not be afraid of court. It pays to be educated in the courtroom. Okay. Especially if you know how to cite case law, which I'll teach you guys how to do in the mentorship. You cite case law, you're like a different animal altogether. They don't want to mess with you at all, because that means you do a lot more research than they do. All right. Step 3, dispute letter contents. You want to include that it fails to meet a valid contract requirements. All right. And there's no novation. All right. Novation means that myself and the original company have to come together and agree in writing that I give them permission to assign my account to another company. So novation means if there is no novation, meaning that I did not go to Sprint and say, hey, I'm okay with you giving my stuff to ERC, they can't do it. Okay. So look up the federal definition of novation and you'll see that. I also want to include these phrases: harassment, FTC, Section 5, unfair and deceptive practices and acts, identity theft, etc. It's unfair and deceptive because we didn't tell them to put on consumer reports. So why is it there? It's deceptive because they are leading people to believe and make this judgments about us and our reputation that we owe this debt to this company. No, we don't. And that's why when you put them in their place, sometimes they're like, well, we're returning this account back to Sprint. Yeah, of course you are, because you don't want the smoke. 15 USC 1681A4, infringement by consumers' right to privacy. By sharing that information without consent illegally, they are infringing upon your right to privacy. All right. This material includes all collection companies. All right. So this can go to any collection company. I don't care who it's from. The more official the company sounds, like there's more violations probably. I had a company that once had it for a client that said the United States Collection Company. That's illegal. It's super illegal. You can't act like, you can't try to represent your, like make yourself seem as if you're a part affiliate of the government. It's illegal. So this is part one of collections. We got a few more parts coming. But yeah, this collection part is fun for me. I'm gonna pull up on the next video. I'm gonna show you guys an example of where the address sometimes doesn't match what the BBB says, and then what to do next. Right, I'm gonna show you guys how to search to verify the search the name as well. So stay tuned. We'll get to that in the next one.